One misconception, for example, is, well, I can fire someone within the first 3 months automatically, right? I mean, the automatic answer someone could think of is yes, but that's actually not true. Unless there's a contract. Okay. That's right. Unless there's a contract that allows for a probation period for that 3 months, and to say you will be terminated within that period without being given anything, then there's no such thing as probation period. So probation period is actually a creature of the contract.
Right. And people take it for granted. They assume, oh, this is by default.
So if you look up the Employment Standards Act, you will not find that there's a probation period. There's a period that within which you can terminate someone and not pay them anything. But that is if your contract actually limits entitlements to the Employment Standards Act.
Right.
If the contract does not limit things to this legislation in front of you, then it's fair game to say that someone was terminated after 1 week and there's no probation period, and now they're entitled to, for example, they could say a lot of money if inducement happened.
Yeah.
Not to snowball how things could spiral out of control, but a lot of the times people like how an assistant works at a different office, for example, and says,
right,
leave your office and come work with me. If that person has been working somewhere for a certain period and you ask them to leave, bring them on without a contract, and you terminate them after 1 week, guess what? You have to essentially now pay them for the period that they've actually worked for the previous employer before you, not just the period that they were with you, because you actually brought them on board and you said, please come, here is what I'm going to offer you. Without a contract, probation periods, like I said, don't exist. And inducement, actually, not to go into bigger balls, but bigger snowballs. I'm sure that will be edited, I hope.
Yeah.
So let me say, inducement, one of the elements to say that we were pushed to leave from our previous employers to say, well, there was no probation period. They wanted me so bad that they said, you come on board, no contract, you're fine. So absent employment contract and inducement argument is a lot stronger now to say. So that's just an example. I'm not speaking as a lawyer here. I'm speaking as a practical person. These are things that can practically happen. And one thing could lead to another. If you have a lawyer on the other side now, unfortunately, people just run to a lawyer for anything and everything. When someone is advertising, call us for free, for example, or we'll take your case for free. Now people are calling for any and all reasons, and lawyers are being creative into digging into minute little details to scare employers with demand letters that, if not properly read by someone who knows what they're doing, do look intimidating. So honestly, it is safer. We said it before, before this call, an ounce of prevention is
worth a pound of cure. Yeah, absolutely. The way I look at it is I think it protects both sides in many respects, because what I have seen happen, not in dentistry, but in other professions, is somebody will be let go and they feel they have a case. And because there isn't a strong contract there, they go, like you mentioned, there's a lot of law firms that will offer free consultations. And, there is an industry built around trying to find and work with disgruntled employees. But it often, from what I have seen in my personal experience, a lot of the time it doesn't work well in the favor of the employee either. And then there's a lot of litigation that happens. There's a lot of money wasted on both sides. And ultimately, nobody is happy with the end result anyway. So if you had that contract where it says, look, it's very clear how this is going to end if it does end, and that way both parties can go their separate ways, right? But if there's always that room for, well, it didn't really work that way and this wasn't really written down, then that person can go down the employee can go down a huge rabbit hole, which again isn't, from what I've seen, it isn't always advantageous for them either. Sometimes they spend a lot of money themselves on legal fees and get nowhere. It wastes a lot of time for the dentist too. And then their profitability and their revenue, their business really goes down because they're focused on dealing with that. And it's like nobody wins here. So I think the contract, when I look at these contracts, I look at it from, it's not just to protect me as an employer. Honestly, it is probably the best interest of my employees too, that it is very clear how things are going to split if they do split. And then we can both move on with our lives and just, we both feel like hey, we agreed to it. This is what a fair termination is. Let's just go our separate ways.
And Nick, a lot of the time, it's not necessarily what is in a contract. It's sometimes the existence of a contract or the existence of a policy or the updating of a policy. That event in itself sometimes for employees sort of shapes their day or their year in a way that the employer is on top of their work with us. Even if we do think that this employer may not be doing things right, they're on top of their work. They must have checked with someone. So that in a way does automatically, in my experience, gives some sense of confidence for employers that the employees know that they're doing things properly as opposed to just shifting them around and doing things not the proper way of doing business.